booked in Muthaiga Police Station by OB 56 of 31st January 2024 at 19:02 hours, where it was indicated that the respondent should be treated as a dangerous suspect and limitations of visitations apply. Therefore, the Deputy OCS Muthaiga Police Station instructed all office personnel and cell security that anyone who wished to visit the respondent must pass through his office. So that, Your Honor, what we have clearly demonstrated in this affidavit is that in order to secure the respondent and make sure that he appears before you pursuant to these extradition proceedings, it is best that he be remanded at Industrial Area Medium Remand. Contrary to the assertions by my learned friends, we do not seek to limit his right to counsel. All we are saying is that the counsels on record appearing for him will have access to him. If my learned friends have any other counsel who they wish to place on record, let us know. They will equally have access to him. Place them on record. We need to know who they are. No. We have no problem. To my learned friend, Mr. Mugama, I think you misinterpreted my statement. I didn't mean that the IO must be present listening to your conversation. No. He must know that you are going to be there. Once you begin your interactions with your client, you will simply step out. The same applies to access to medical facilities. We are not seeking to curtail any fundamental rights of the respondent, none at all. All we are saying is that we will do it in a manner that ensures that we secure him and make sure that he is available when and required in court. Malane friends talk of any other police station. Your Honor, we are the ones who know and have the knowledge as they say, the wearer of the shoe is the wearer, knows where it pinches most. Once bitten, twice shy. That's all I can say. So we cannot take that risk. They are still police stations. So we humbly beseech this honorable court to grant us the order sought. And I would like to repeat, and these are the remarks of the DPP, we are ready and willing to prosecute this case as soon as possible, even from next week we begin. That will be all.
Yana, the court allows a little latitude. My learned colleague for the state has raised some issues in their response that Yana, we did not address them, that we raised them. The issues to do with Section 8 and Section 19. It's a wrong reading of the law and misleading of the court. You know, the moral arc of the universe is long, but it comes towards justice. We seek for equality of arms. We did not want to interrupt my learned colleague when he was submitting. So with humility, we seek time to correct the position as on record, for the court to get a chance to hear us on our submissions with Section 8 and Section 9 of CAP, and Section 19 of CAP 76. The procedural.
You made the application. You responded.
Yes.
Yes, you did. And in his only restated as correctly as it is in black and white.
So if we allow you to come up again and respond to the reply, then you will again have to reply to your response.
Not indeed, my lord. The law is static, and I believe
if what he has read saying is Section 17 and 18 is not correct, I'll have to read it first before doing my ruling.
that's why as I made submissions on the same. That my lord, that your honor, it's good that you hear our response on the same as you return to make your finding on the same. We'll be brief. We pray for 2 minutes.
Your Honor, I cannot allow that. He had an opportunity to respond.
We did not raise those particular issues. However, in his further response, he raises them. That's an attempt to steal a match. And with humility, we seek you hear us, and then you'll make your informed decision on that.
To have some kind of
It's all right. It's all right, Your Honor. We know that. We know that. However, Your Honor. Sorry.
I want us to come to an understanding on this. In your response, you asked for
station.
That's correct.
That was a point which your colleague had the right to reply on.
That's fine.
And now in his reply he says that the law does not allow the court to remand at a police station but in prison.
That's right.
What is new there now?
What is new is that when making that response, he relied on the affidavit Inspector Patrick Bashira, and when at it, was the first motion. Endorsement of the warrants. So I believe it's a matter of putting the card.
Now I see your point.
Yes.
Mr. Monda. Yes.
Before you, there's an application dated 31st January 2024. Where the state seeks that the Honorable Court does endorse the warrants dated 2nd November 2023. Issued by the Chelsea District Court in the county of Suffolk, Commonwealth of Massachusetts. It's our submission that Section 8 of Cap 76 can only be invoked upon the endorsement of the said warrants by this Honorable Court. Lastly, Your Honor, Section 19 of Cap 76 addresses an instance where a prisoner escapes from prison pursuant to their detention under Section 8. Thus, Your Honor, as I conclude, the prayer to seek or the request to seek that the respondent before you be held at industrial area remand or any other remand in this country cannot be granted until the motion dated 31st January 2024 has been judiciously disposed of. That would be all, Your Honor, unless the court has a question for us. Thank you.
Your Honor, Section 8 should be read together with Section 19.
Your
is what Section 19 says. If a prisoner escapes by breach of prison or otherwise, out of the custody of a person acting under a warrant issued or endorsed pursuant to this act, or out of custody or out of the custody of a person to whose custody he has been committed in accordance with this act, he may be retaken in the same manner as a person accused of a crime in Kenya. So this is prison. So you cannot read Section 8 in isolation with Section 19. If you commit a crime, taken to prison. So that, Your Honor, our position is simple. He escaped lawful custody. From Muthaiga police station where he had been ordered. The Act says if you do that, you are treated as a person who has committed a crime. Therefore, Your Honor, we are asking that you order the respondent to be held at Industrial Area Remand Prison as sought by the applicant. That will be okay.
And you don't have a common stand, so I may be forced also to look at it and cross-check so that I don't make a ruling that is in itself a mistake. And I had interrupted the normal flow because you were not yet done with the course list.
Yes, I do agree that to that. So just let us know when you...
It has to be today, because if I don't make it today, then now what do we do with the respondent?
Very true. So maybe later on today.
Yes, maybe in the afternoon. I had some work that had deadlines yesterday and I had overlooked. So my boss reminded me yesterday that I met the deadline. So my plan was to come and clear early, go finish the assignment, submit, then I come back. So if you come at around, it's 3 o'clock too late. I think 3 o'clock I will be done with the rest of the work, and then I'll also have done this ruling.
That is okay, you know.
You want a 1500 hours?
We are used to 3 p.m.
3 p.m. 3 p.m.
Yes.
Thank you.
You're
It's a
welcome.
Valentine's Day, but
Yes. You're welcome. Sorry, just a humble request. You see, this is just one of the many cases that we still have. We will need the gentleman to leave his position so that we are able to proceed with the other cases. So, media guys, he will be back again at 3. You're welcome.